Mr. Flengy, we let Mr. Purcell go a little bit over, so I'll give you 5 minutes for rebuttal.
Thank you very much, Your Honor. I just want to address a couple quick points. First, DIN. Whatever DIN says about looking at consular decision-making does not suggest that we look behind a national security determination made by the president, where that determination, the four corners of that determination, are explicitly based on the congressional determination that the countries at issue are of concern and does not go beyond that.
I thought you were using DIN and Mandel as your main authority for the unreviewability, and so now you're saying those are distinguishable. I'm a little confused whether you're relying on those cases or not.
We are definitely relying on them for the limits that courts review these types of issues. I'm adding that when you have the document itself, and that is the best evidence of the intent of the president, it relies exclusively on the calls made by Congress and the administration in 2016 about the safety concerns presented by the specific countries at issue. That is the end of the inquiry and should be. In fact, the counsel for the other side cited this court's recent Cardenas decision, and there, in describing the state of the law, the court very clearly said that Congress could have enacted a blanket prohibition on I think it was describing Mandel, on communist aliens, and that is, and here we have the president making a categorical determination based on the identification of countries of concern, and there is nothing strange.
You answered the question that was asked earlier about what if the order said no Muslims. You've been analogizing to cases that were about people who were communists who advocated overthrow of the U.S. government. And are you saying that the external evidence here that is alleged that the intent here was to ban Muslims is equivalent to that?
If there were an executive order that prevented the entry of Muslims, that there would be people withstanding to challenge that, and I think that would raise Establishment Clause, First Amendment issues. But that's not the order we have here. This order is limited to the countries defined by Congress. And let me, on the refugee point,
are that was the motivation, and plaintiffs have submitted evidence that they suggest shows that was the motivation. So why shouldn't the case proceed, perhaps to discovery, to see if that really was the motivation or not?
We're not saying the case shouldn't proceed, but it is extraordinary for a court to enjoin the president's national security determination based on some newspaper articles, and that's what has happened here. That is not that is a very troubling second guessing of the national security decision made by the president, and the notion that we are going to go back into court and
stop. This is Judge Clifton. Do you deny that, in fact, the statements attributed to then candidate Trump and to his political advisors, and most recently Mr. Giuliani, do you deny that those statements were made?
Judge Clifton, no. I would note that Judge Robart himself said that he wasn't going to look at campaign statements. I do, and I think that what
you see, that's a different point. I mean, I understand the argument they shouldn't be given much weight, but when you say we shouldn't be looking at newspaper articles, we're all on the fast track here. Both sides have told us it's moving too fast. Either those kind of statements were made or they're not. Now, if they were made, but they were made not to be a serious policy principle, I can understand that. But if they were made, it is potential evidence. It is a basis for an argument. So I just want to make sure I know what's on the table.
Well, those are in the record, but I think my point is a little narrower, that in the expedited procedure of a TRO, taking this extraordinary action of halting this order that the president determined was in the national security interests of the United States is an unwise course, and it should be stayed.
If we thought there was a problem that this is too preliminary, if we let this go forward to a preliminary injunction hearing, do you have evidence that you would present?
I think we definitely would like the opportunity to present evidence back in the district court, and we also think that the scope of this lawsuit really needs to be.
Can you tell us anything about the type of evidence you would present so that we can consider that whether further proceedings are needed?
Not yet, but I do. Another point is the scope of the suit and the injunction would really need to be narrowed as the parties focus in on the actual harms. The harms that Washington has cited focus on residents of Washington, but the order goes way beyond that to the areas of the most concern of the president, people who have never been to this country yet and have no connection to Washington, no connection to the United States, and no claim of constitutional rights, either on their own or through Washington.
If I can ask my colleagues to indulge me for a moment, that does raise a serious concern on my part, and the scope of the order, most obviously having to do with the lawful permanent residents, which the government's position now is they're not included within the scope of the order. I have to say, is there any legal authority for the counsel of the president to have power to instruct the other departments or to instruct us as to what the order means? I mean, the president can amend the order, but I'm not sure that the counsel of the president has that authority. So why is it we should be looking at this reconceived order, and why is it we should, rather than try to narrowly carve out the injunction you're asking for, and those are practical problems. I don't know how I'd write such an order. Why shouldn't we look to the executive branch to more clearly define what the order means rather than have to look through the lens of these subsequent interpretations?
Let me make 2 points there. One, the guidance from the White House counsel is the definitive interpretation of the order, and the White House counsel speaks for the president in this context. Second, in our reply brief at the very end on page 11, we had our kind of suggestion for the kind of order that would actually address the harms identified by Washington. And there I'm going to read that. At most, the injunction should be limited to the class of individuals on whom the state's claims rest. Previously admitted aliens who are temporarily abroad now or who wish to travel and return to the United States in the future. That is the core of the harm they've identified. When we're talking about an injunction entered on such a preliminary basis, it should be limited to the claims that the state is making and not issued more broadly. If there are no further questions, I encourage the court to stay the injunction or to limit it to the presentation of the state of Washington. Thank you.
Thank you, counsel, for your very helpful arguments. This matter is submitted. We appreciate the importance and the time-sensitive nature of this matter, and will endeavor to issue our decision as soon as possible. Thank you again for appearing on such short notice. We are adjourned.